Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 8 about civil liberties. It's Lesson 5, which is our third lesson about the content of the Bill of Rights. In this lesson, you'll learn about the Sixth Amendment, the Seventh Amendment, and the Eighth Amendment. In previous lessons, we've talked about how the Bill of Rights was added to the Constitution all at one time. The first 10 amendments to the Constitution constitute the Bill of Rights. In previous lessons, we've discussed the 9th and 10th Amendment first, then we talked about the 1st, 2nd, and 3rd Amendment, and then the last amendment we talked about the 4th and 5th Amendment. That leaves us in this lesson to discuss the 6th, 7th, and 8th Amendments. As we do this, let's please remember that the Bill of Rights was added to the Constitution specifically because of concerns about powers of the national government. It was added as a way to check the powers of the national government. And we should always keep that in mind as we read the amendments in the Bill of Rights, to think about how this particular thing is in some way controlling the national government, stopping it from becoming oppressive and tyrannical. And that goes for the amendments that we'll discuss today also. The 4th and 5th Amendments were about fair legal processes. The 6th, 7th, and 8th Amendments that we'll discuss in this lesson also are about fair legal processes. So when you take that together, we've got 5 of the 10 amendments added to the Constitution and the Bill of Rights that are about legal processes. The reason for that is because, as we've discussed in previous lessons, the court system, founded upon jury trials, with your fellow citizens deciding whether or not you are guilty and whether you should go to prison, were considered a foundational way of protecting us as a people from an out-of-control government. The government might want to inflict punishment upon people because they are the government's political enemies, but a fair court system based on jury trials will stop the government from doing that, because it's we, the people, that decide whether this person should go to prison or not. And if we make sure that the government can't send them to prison without our consent through the jury system, if we make sure that the government, as they're conducting the trial trying to convict them, has to actually do it fairly, then we can at least hope that it'll be a system where the government is unable to just punish its enemies, but has to actually only punish real criminals. So now let's begin to talk about these last 3 amendments that we need to finish our survey of the Bill of Rights. So we're going to discuss the 6th Amendment to begin with, which concerns fair criminal trials. We're going to talk about 4 different aspects of the 6th Amendment. The first of those is the idea of a speedy and public trial. Here's what the text of the 6th Amendment says. In all criminal prosecutions, the accused, in other words, the person who the government is saying committed the crime, broke some sort of law, shall enjoy the right of a speedy and public trial. Well, what does that mean? First of all, the speedy part means that a trial cannot be excessively delayed. The government can't arrest someone and throw them in prison and then just leave them there for years, awaiting eventually to get a trial, where maybe a jury will decide to let them go. It has to be done in some sort of prompt fashion, or the government has violated this provision of the Bill of Rights and the person will be released. In addition to this, when the trial does eventually happen, it cannot be conducted in secret. It has to be a public event. In the photograph on this page, you can see a picture looking through the doorways of a courtroom. And what you'll notice is, way in the distance is the judge's bench, and there's chairs there for the lawyers for each side and for the person who's accused. And then off to the right-hand side in the distance, you can see the seats for the jury. But closest to the door, there's a bunch of seats. What are those for? They're for the public to come and observe the trial proceedings. In our American system of justice, trials are open to the public. You may not even know this, that you could go down to the courthouse in your town, And whenever there's a trial going, you can potentially go in and just watch the trial. If there's room for you there, some trials are events that lots of people want to come see, and maybe there won't be a seat for you. But most of the time, there's probably going to be a seat in the room if you just want to go watch a trial. The reason for this is to make sure the government can't just secretly capture someone and claim that they've convicted him and throw him in prison without the public ever having an opportunity to see for themselves if this is what has really happened. The second item that we want to talk about in the Sixth Amendment is the promise of an impartial jury. That's what the actual text says. It says that in all criminal prosecutions, the accused will enjoy the right to an impartial jury. Well, what does that mean? It means that juries cannot be biased. They can't go in thinking that this person is already guilty for some reason. And there's mechanisms set up at trial to try to ensure that this will happen. For example, the lawyers for the accused get to interview potential juror members, get to talk to them, ask questions. And if they sense something in their answers that leads them to believe that this person to be biased against their client, they can ask the judge to remove that juror and select somebody else. It's a way to try to ensure that the jurors will judge the case based on the facts, not because they already know the person who's being accused and don't like them, or maybe they don't like the person's race or whatever it is. Oh, which, by the way, also another thing that could happen with a biased jury is that the jury could be biased pro-government. Essentially, the government, if they wanted to get convictions of their political enemies, they could stock the jury with people who want to punish the accused because they're an enemy of the government. In an impartial jury system, those kind of people would be removed for bias also. Again, potentially protecting us against a tyrannical government. Okay, to continue on. The next item in the Sixth Amendment that we want to talk about is the ability to confront witnesses. What the actual text of the Constitution in the Sixth Amendment says is that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Now, what this means is that witnesses can't testify in secret. They have to actually be brought into the courtroom where the person is that they're accusing of having done something bad. They have to make their accusations in front of that person, and it gives that person then the opportunity to confront them back. It's much harder to lie about somebody to their face. And so rather than them just giving some secret document somewhere where you never know whether they even actually said the things that it's claimed they said, instead they have to say those things in open court for the accused to see and respond to call them a liar, whatever it is, to confront them, but also for the public to see what they're saying, so they can take confidence that that's really what has been said. So the accused has to be confronted by the people that are testifying against him. And at that point, he has an opportunity to confront them back, to cross-examine. Well, he's probably not the one that's going to be doing it. It's probably going to be his lawyer doing it. Which, by the way, in this picture, it isn't a lawyer about to punch a witness. It's a lawyer demonstrating to the witness what the witness has said, saying essentially, okay, is this what you mean happened? That sort of thing. So it's an opportunity for a lawyer to be confronting the witness, trying to figure out what they actually said and whether what they said is true. And this is something that every accused person has an opportunity to do through either themselves or their lawyer. Last item in the Sixth Amendment we want to discuss is assistance of counsel. The Constitution says in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for their defense. This means that a person accused of a crime can be assisted by an attorney. If they want to go get an attorney to help them with their case, they are constitutionally guaranteed that opportunity. Now, they don't have to. They can argue the case themselves if they want, but the government cannot stop them from getting a lawyer if they want. Now, this is a way to make sure that people have the expertise necessary on their side to not be railroaded, to force through this process by the government without ever really having a chance to win. Again, it's another way to stand up against a potentially oppressive government. Now we'll move on to the Seventh Amendment. The Seventh Amendment, unlike the Sixth Amendment, concerns now civil trials. Now, recall, please, from earlier in this course, we learned about the difference between criminal and civil trials. Criminal trials are about breaking the law and possibly being punished by the government. Civil trials are about having hurt someone, harmed them in some way, and then possibly owing them money for the harm that you did. The Seventh Amendment says that in suits in common law, we're talking about suing someone for money, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. Now, this is a little bit crazy because $20 in 1791 is about the same as $500 today. But it says $20 in the Constitution, which means that if you're in a lawsuit for over $20, and it's a lawsuit that should be in the national court system, then you get a trial by jury. The government has to go through the expense and trouble of providing a jury for you. Now let's finish up with the Eighth Amendment. The Eighth Amendment concerns what punishments may be inflicted upon you by the government if you are found guilty. Now it says a couple of things in here about no excessive fines, no excessive bail, that kind of thing. Don't worry about that. The thing I want you to remember from the Eighth Amendment is that it says no cruel and unusual punishment can be inflicted upon you. Now, that most obviously is going to say that you cannot be tortured. I think just about anybody you'd ask, say, define cruel and unusual punishment, probably the first thing that's going to come to mind is some sort of torture. But just saying it covers torture, and therefore that's not allowed by the government, isn't really answering the question, because then we have to ask, well, what is torture? Or more broadly, what constitutes a cruel or unusual punishment that is not allowed by the Eighth Amendment? Here are some potential examples. In the upper left-hand corner, we have an overcrowded prison. Is that cruel and unusual? To be stuck in a place with too many other people. In the middle at the top, we have a pillory, a kind of punishment that was commonly used at the time of the founding of the United States of America, and certainly was not thought cruel back then. The next photo on the right, on the top row, is of someone being flogged, being whipped across their back. Well, is that cruel and unusual punishment? I think according to today's standards, it would be considered such, even though it was common at the time that the Eighth Amendment was included in the Constitution, which shows how the court's understanding of what is cruel or not cruel has changed over our country's history. On the bottom right, we have a chain gang, prisoners that are being forced to go out and work as part of their time in prison. In this case, it's women who've been arrested for DUI in Arizona, and the sheriff sends them out on these chain gangs to work, hopefully to discourage them from behaving badly in the future. This has actually been allowed by the courts. And then on the bottom left, we have someone being branded. This was a common punishment, again, back at the time of the American founding, that would not probably be allowed today. But in some ways it makes sense. Like, for example, a punishment for someone being dishonest in business would be to have a certain letter branded on their thumb. Then when they went into the future to engage in a business deal and they'd stick out their hand to shake hands, their potential partner would see the brand on their hand and realize that they'd been dishonest in the past, and then maybe refuse to do business with them. It's a very appropriate punishment for the kind of crime they committed. But today it would probably be considered too cruel by the courts and wouldn't be allowed. So the courts have evolved, have changed the meaning of cruel and unusual punishment over our country's history, perhaps for good or ill. I know personally, if I were arrested for a crime and convicted, and then I was given a choice between going to prison for 5 years or getting 5 lashes with a cane out in a public square for everybody to see, I would take the lashes and then go on with my life rather than spend the next 5 years in prison. And I would personally consider prison to be more cruel than the whip. But the courts see it differently. All right, now let's review what we learned in this lesson. What does the Sixth Amendment require of criminal trials? Does it only require them for serious crimes? Are they conducted before 3 judges? Are they open to the public? Or must they be completed in only 1 day? The Sixth Amendment requires that trials be before the public. What does the Sixth Amendment require of criminal juries? Must juries be composed of 15 people? Must they be representative of the racial composition of a community? Must they be unanimous with their verdicts? Or must they be impartial? The Sixth Amendment requires that juries be impartial, in other words, unbiased against the person accused of a crime. What does the Sixth Amendment require regarding witnesses? Must they confront the accused? Must their identities be protected? Must they be older than 18, or must they only be men? The Sixth Amendment says that witnesses must confront the accused. What does the Sixth Amendment mean by the right to counsel? Does it mean that you may talk to a judge, that you may talk to a jury, that you may have a lawyer, or that you may meet with your accuser? The Sixth Amendment right to counsel means that if you're the person accused of a crime, you may have a lawyer to help you. For what are juries required by the Seventh Amendment? Are they required for lawsuits over $20, for murder trials, for impeachment, or for property crimes? The Seventh Amendment requires juries for any lawsuit over $20. What punishments are prohibited by the Eighth Amendment? Is execution prohibited? Is imprisonment prohibited? Are fines prohibited? Or is torture prohibited? Torture is prohibited by the Eighth Amendment. Okay, that completes this lesson. The next lesson will also be from Unit 8. It'll be Lesson 6 about selective incorporation.